just remind you the live streaming is still on. This is a judgment of the court. This is an application for permission to appeal against orders made by PLJ in respect of a baby girl, Indy, who was born on the 24th of February 2023 and is a patient at the Paediatric Intensive Care Unit of Nottingham University NHS Trust. She is the much-loved child of devoted parents, and as the judge said, quotes, "This case is about the precious life of a very young person, a family member, and an individual in her own right." The application for permission to appeal is in relation to the order of the 16th of October 2023, made by Mr. Justice Peel, sitting in the Family Division of the High Court. The effect of his order would be that Indy, who is currently on a ventilator, would be extubated and provided with non-invasive ventilator support for a period of up to 7 days. Once extubated, the judge declared that it was not in her best interest to again be intubated and provided with aggressive care or painful intervention. After a 7-day period of post-extubation, if Indy continues to require non-invasive ventilation, it is in her best interest to be provided with compassionate care only. And there is a compassionate care plan within the bundles before the court. Any further invasive or non-invasive ventilator support will not be provided unless her treating clinicians consider it appropriate, but they cannot be compelled to do so. It's against those declarations that an application for permission to appeal is now made. Mr. Quintavalli, on behalf of the applicant father, was frank as to his position, and in his opening remarks, reiterated again in closing, he said that the father accepted that the decision the judge made may well be right, and that he was not saying that the judge was ultimately wrong in his conclusions, but rather, absent the father having adduced his own independent expert evidence, the judge did not have a sufficient evidential basis upon which to reach his conclusion, the more so in such a serious case. For this court to grant permission to appeal, it must be persuaded that an appeal against the making of that declaration would have a real prospect of success, or that there is some other compelling reason for an appeal to be heard, pursuant to the Civil Procedure Rules 52.6. That test is not satisfied, permission must be refused. Background. It was known before her birth that Indy had a hole in her heart between the two main chambers of her heart, and it was almost immediately found to have a teratology of fallout, which is a combination of heart defects. She was soon diagnosed also with intestinal malrotation, for which she underwent surgery, and in June 2023 a diagnosis was made of combined D2-LT, a mitochondrial condition. IG suffers from a number of significant and serious disorders. 1. The combined D2-L2, a metabolic disorder that causes progressive damage to the brain. The disorder is characterized by epileptic encephalopathy, respiratory insufficiency, abnormalities in the brain, developmental arrest, and early death. In addition to that, she suffers from a severe bilateral and progressive ventriculometry, which led to enlarged brain ventricles from a buildup of spinal fluid, and also her heart condition, which affects normal blood flow through her heart. As a consequence of these serious conditions, Indy is provided currently with multi-organ support and has the highest level of intensive care, one-to-one care, 24 hours each day. The judge set out in summary the progress of Indy's various medical conditions in his judgment. Indy has now been on full life support since 6th of September 2023. She's critically ill, intubated, ventilated and sedated. What is uncontroversial is that the nature of her various conditions has meant that this tiny baby has suffered from extensive invasive treatment in order to keep her alive. This has included surgery for intestinal malrotation, the fitting of a shunt in her brain to assist with the buildup of fluid, the drilling of a needle into her bones on numerous occasions in order to deal with her challenging IV access, on 8 separate occasions requiring intensive care or NCIU ventilation, and on 3 occasions having CPR when she went into cardiac arrest. On at least 2 other occasions she's had blood transfusions. It has now reached the stage where it is simply too dangerous for an MRI scan to be carried out in order to see the extent of any further deterioration of her brain. She suffered from frequent and serious desaturation episodes. It is common ground that the hospital has sought advice nationally and internationally and has been open to and attempted novel experimental treatment. However, after a serious desaturation episode on the 6th of September of this year, Indy was fully intubated and has been intensely ventilated ever since. The evidence from the clinicians who gave evidence before the judge was that the current level of care might prolong her life for a few weeks or even months, whereas without such treatment, her life expectancy can be measured in days or a week or 2. Pain. No parent would wish to see their child in pain, and this father is no different, and has had to watch almost since his child was born the complex medical treatment she has had to undergo. In his composed and dignified evidence, the father expressed to the judge his belief that Indy experiences some pleasure, and he was adamant that she does not experience significant pain. His view was and is that any minor distress is outweighed by the benefit of continued life. Unhappily, that understandable view is contrary to the evidence. The judge set out the evidence of Dr. E, paediatric intensivist, at paragraph 32, Roman 7, as follows, quotes, Dr. E has himself observed episodes of distress and agitation which the bedside team see multiple times a day. The current treatment causes Indy pain, exposing her to harmful procedures and therapies which provide no long-term benefit. She displays signs of distress during interventions, open brackets, such as handling, suctioning, use of IV lines, blood tests, close brackets, and reacts to painful stimuli, including crying, open brackets, tears well up in her eyes, close brackets, increased heart rate and mottled skin, wincing, gasping. These episodes of distress can last up to 10 minutes. In addition, the judge heard from a member of the nursing staff who said, quotes, she told me that IG is distressed by the various interventions. She struggles to breathe, winces, coughs, and her eyes fill with tears. This takes place several times a day, often lasting several minutes in response to medical intervention. In addition, the court has had the benefit of an update of her condition as of today, for which I'm grateful to the paediatric intensivist who provided it for our assistance at very short notice. In that statement, he says as followed in relation to her distress and agitation, quotes, we attempted to wean her sedation at the beginning of the week as she was a little calmer, but then needed to go back up above her previous level as she was significantly distressed and agitated. The nursing team have told me that she's had prolonged episodes of distress and being unsettled, especially linked to fevers and after large stool motions. The continued and prolonged distress is exhibited by disordered breathing, grimacing, squirming, and crying. He then details the pain relief which she is currently prescribed, finishing by saying, "This is a significant amount of pain relief / sedation, and as set out above is above the previous level provided as at the date of the final hearing." Even before that update, showing that the levels of pain Indy is suffering is even greater now than just a couple of weeks ago, the judge held at paragraph 43, quotes, "I take the view that the parents do not recognise the pain she is suffering, perhaps because, as the guardian put it, they see Indy through their own lens. That is completely understandable. They are hoping against hope for something positive to emerge. However, the evidence clearly establishes that she experiences significant pain and distress several times a day, and painful episodes last up to 10 minutes. Such pain is caused by her multiple treatment interventions, including invasive ventilation, suction, use of IV lines, blood tests, and the like. It will continue for as long as the interventions continue." Infection. The father had at one stage thought that the fever to which Indy is very susceptible was caused by infection. In fact, that is not the case. It is part of the deterioration of her brain function. At the hearing on the 3rd of October, the father agreed for her antibiotics to be stopped as there had been no evidence of infection since towards the end of August. So it was against this desperate background that the hospital made their application on 7th September 2023 on the basis that continued invasive intervention was not in Indy's best interests. In the majority of these sad cases, the doctors and clinical team and the family members together are able to reach an agreement about how and when treatment should continue, and whether treatment ultimately should be withdrawn. But where there is disagreement, an application may be made to the court, as has happened here. As the judge observed, it is necessary in all of these cases to consider the entire picture of this profoundly sick little girl. By way of example, her heart condition on its own would be treatable, but as recently as the 4th of October, at a joint cardiac conference at the Birmingham Children's Hospital, it was concluded that her presentation is not materially caused by her heart condition, and the cardiac team were not given her overall condition willing to provide the treatment for her heart. Indy's parents accept that she is very fragile and that she has a limited life expectancy, but they say that she shows no serious pain and she is currently stable, and that the precise causes of her presentation is unclear. They can, they believe, achieve some autonomy in the future. The judge, however, found that she is on a rapid downward trajectory and is at the limits of what is medically available for her, a view confirmed by the updating medical evidence put before the court today. It was against this background that the judge held as follows. Quotes, "The medical evidence is unanimous and clear. I accept what I was told by Dr. E, Dr. S, and the nurse. I am satisfied there is no gap which needs further inquiry. Tragically, Indy has an incurable condition, which, combined with her other morbidities, will lead to a fatal deterioration within at most a few months, even if she receives ongoing full critical care, and probably a few days if invasive interventions are withdrawn. Beyond prolonging life, which in itself has a value and to which I pay high regard, treatment is futile. There are no curative therapies. Indy is progressively deteriorating and highly unstable. She has reached the limit of what medicine can achieve. She will not recover from or even have minor improvement to her life-limiting conditions. Her short life has consisted of cycles of stability, punctuated by episodes of acute care associated with painful stimuli, leading to the most severe episode of all in early September, from which she has not recovered. Physiological deterioration is occurring regardless of treatment. Cardiac treatment will not address the underlying incurable disease, nor on the evidence is it a feasible option, as it is clear no cardiological treating team would be willing to provide any cardiac intervention. CPR would be without any purpose for the reasons outlined by Dr. E. The parents' belief that her presentation has been caused by infection since early September is not supported by the evidence. ... Although the father's case, as presented through counsel, advanced the proposition that the causes of her presentation are unclear, how the various morbidities interlink is unclear, and whether alternative treatment may provide better results is unclear, I do not agree. Medical evidence about this little girl is compelling. All her issues are interlinked, and her diagnoses and conditions, viewed in the round, lead to her current presentation. I am satisfied, said PLJ, that there is nothing more that can be realistic done by the treating team. Similarly, on occasion, questions were put to witnesses about the hypothetical treatment for a child not suffering from Indy's particular conditions, but ultimately the clinicians and the court are concerned with this particular child and with this range of presentations. Close quotes. I turn then to the grounds of appeal. Grounds 1 and 2 relate to the judge's case management decision not to grant permission to the instruction of a raft of experts with the intended delay which would result. Whilst ground 1, anxious scrutiny. Whilst ground 1 is framed as a failure to provide anxious scrutiny to the case, in circumstances where the fundamental right to life is at stake, its focus is on the absence of extensive further expert evidence commissioned on behalf of the father. The depth of the inquiry it is submitted was inadequate to decide a matter of life and death. Having considered the judge's judgment with care, it is clear to anyone who may read it at neutral citation 2023 EWHC 2556 FAM that this judge gave this case extremely anxious scrutiny and was at all times conscious of the importance of prolonging life, a matter to which the judge said at paragraph 40 he had, quotes, a high regard, close quotes. Drawing on MacDonald J's summary of the law in Manchester University NHS Foundation Trust v. Fixter, 2021 EWHC 1426, 2021 4WLR 95 at 95, the judge reminded himself both that there is a strong presumption in favour of taking all steps to preserve life, and also that there will be cases where it is not in the best interests of the child to subject him or her to treatment that will cause increased suffering and produce no commensurate benefit, quotes, giving the fullest possible weight to the child and mankind's desire to survive, close quotes. Expert evidence. At the hearing on 3rd of October, the father filed an application for leave to adduce evidence from experts in 4 disciplines: a mitochondrial expert, a neuroradiological expert, a consultant cardiologist, and a paediatric intensivist. The test to be applied to applications such as the present, namely for this declaratory relief under the inherent jurisdiction, is found in Part 25.4.3 of the Family Proceeding Rules 2010. To be applied by a court when considering an application to obtain expert evidence, and the test is whether such evidence is necessary to assist the court to resolve proceedings. Mr. Quintavalli mentioned Section 13 of the Children and Families Act 2014, but did not explain with specificity as to how its application to the case would have made any difference, and accepted that the test was essentially the same, namely necessary, but with some variations. He helpfully made clear that this was not a ground of appeal, but, he said, a backdrop to his main submissions. The judge refused the application for expert evidence in an extempore judgment, which he summarised in his substantive judgment as follows. Quotes. And then insert that passage, paragraph 20, little 1 to little 6, please. Although not considering it necessary, the judge on 3rd of October did, however, grant permission for the instruction by the father's team of a paediatric intensive who had been identified by them, on condition that the report was available no later than the 7th of October. The report was not, as it turned out, ready, and no application for an adjournment was made on the father's behalf at the start of the hearing on the 10th of October. As part of the same directions, the judge arranged for questions to be asked by the father at a cardiac conference at the Birmingham Children's Hospital, which had been convened for the next day. The two questions already referred to were whether Indy's current presentation could be attributed to her heart condition, and would the cardiac team be prepared to offer any treatment for her heart defect? The answer to both questions was no. The Trust identified 4 clinicians upon whom they relied and were available to give evidence. The principal evidence was given by Dr. E, a paediatric intensivist. But Dr. S, a paediatric intensivist from another hospital, also gave evidence that further treatment was not in Indy's best interests. A paediatric respiratory consultant and a paediatric consultant with an interest in inherited metabolic disease were also available to give evidence, but were not required on behalf of the father for cross-examination. The time estimates for oral evidence had been agreed between the parties, and no late application was made to suggest that the time estimate of 1 day was insufficient. The judge found Dr. E to be, quotes, sensitive, thoughtful and compassionate in his evidence, wanting the best for Indy, but his view of what is best is different from that of Indy's parents. I should note also that the judge had formed the view that the treating team at the hospital as a whole is one of, quotes, the utmost skill and dedication devoted to the care of Indy, close quote. The judge also heard evidence, as noted above, from a sister in the paediatrical critical care team in relation to the levels of distress demonstrated by Indy and observed by the nursing team. As noted, the judge had heard evidence from a Dr. S from the paediatric intensive team from a different hospital. His conclusion was that, quotes, very sadly, further ventilation, painful procedures or resuscitation is not appropriate. This is on the basis that physiological deterioration is occurring regardless of treatment, and that the severity of her progressive neurological condition is such that she can no longer benefit from continued life, close quotes. The judge rightly took into account all the evidence which was available, including the written statements and the documents exhibited to them, which were properly before the court. Some extra material came in after the judge had sent out his draft judgment, which was in relation to the diagnosis of diabetes insipidus. No objection was taken by any party to the judge having taken this material into account. The evidence overall demonstrated not only Indy's parlous state, but also that the Trust had investigated treatment options, not only locally, but also nationally and internationally, and had tried at least 3 different experimental treatments. It's not necessary to set out a full list of the various specialists who have considered Indy's case, but in summary they amount to little 1, 4 metabolic specialists, including experts from Sheffield's Children's Hospital Specialist Centre for Metabolic Diseases and a specialist professor in Germany. 2, a paediatric intensivist from Birmingham, a consultant in paediatric respiratory medicine, a consultant in neuroradiology, and consultant cardiologists from both Leicester and Birmingham. The father, in his skeleton argument filed on his behalf, is not therefore correct to suggest that the consideration by the judge of Indy's best interest was limited to, quote, the applicant trust's intensive care consultant, close quotes. Mr. Quintavalli has set out at considerable length and of considerable assistance all the types of his expert he would have wished to give opinions, each from their own area of expertise. But as Dr. E explained, Indy's life expectancy is not as the result of one particular diagnosis per se. It is as a consequence of interlocked conditions and causes. Her problems are intertwined, impacting across various conditions and disciplines, and cannot and should not be compartmentalised. It must be remembered also that the judge was making the decisions he made against the backdrop of this being an urgent medical treatment case, which of course included her current condition and the judge's findings in relation to her pain and distress. The hearing therefore took place for one day on the 9th of October. No application was made for a further adjournment, either at the beginning of the case or after the evidence was heard. The judge, however, said, quotes, "Nevertheless, throughout the hearing, I bore in mind the possibility that the unfolding evidence might raise points or queries which would justify additional expert input. In the event, having heard the case, I am quite satisfied that there is no need for any additional expert evidence." Nothing in the material before us showed that even if there had been further expert evidence, it would have made any difference, and the information before the judge was clearly, in our view, more than sufficient for him to reach the decision he did in the circumstances. The fact that the evidence rightly recognises that there were uncertainties in relation to her condition does not mean that further expert evidence must be required. There are always, and inevitably are, questions which remain unanswered in these cases of vanishingly rare mitochondrial diseases. The evidence that her condition is incurable and is causing her significant pain and distress is clear and compelling. Accordingly, there is no real prospect of this appeal succeeding on ground 1 should permission to appeal be granted. Ground 2. Ground 2 raises many similar issues, but as Mr. Quintavalli pointed out, goes more to procedural irregularity, and in particular his submission that the way the judge ran the case with no expert evidence on behalf of the father meant that there had not been equality of arms, as only the trust had had the realistic opportunity to adduce evidence about Indy's medical condition. Mr. Quintavalli seeks to argue that in order for the trial to have been fair, he should have been allowed to call the raft of experts, and in this context he referred the court to a series of European cases in relation to a party calling their own expert evidence in order to achieve equality of arms, most especially when the right to life was engaged. But whilst equality of arms is of course the backdrop to any consideration of an application to adduce expert evidence, it is not suggested that the applicable rules and legislation which govern the admission of expert evidence, not only in this area but in all areas of the law in this jurisdiction, is not HR compliant. The judge is therefore entitled to refuse applications for experts, as he did in this case, the careful reasons he gave, whilst giving the father the opportunity to obtain a paediatric report, if it could be obtained, within the timescales for Indy. Not only did the judge, however, give the father every opportunity to test the evidence of all 4 of the clinicians, but, as is clear from the order of the 3rd of October, he facilitated arrangements to be made for him to have discussions with a consultant neurologist to help him to better understand the prognosis. And on the 4th of October, as already mentioned, the Joint Cardiac Conference was held in Birmingham, where the questions to be considered were agreed between the Trust and the father. Mr. Quintavalle seeks to compare Indy's case with that of the well-known case of Charlie Gard and a host of other medical treatment cases. In our judgment, it is not helpful to attempt to draw on another case in this way, in relation to a different patient on different facts in wholly different circumstances. It should be noticed that this case is not unique in a court making case management decisions on the very specific facts of a case that no further medical evidence is necessary. See, for example, St George's NHS Foundation Trust v. Casey, 2023 EWCA Civ 1092. Notwithstanding Mr. Quintavalle's careful and detailed submissions, in my judgment, there is no real possibility of a court concluding on appeal that the judge had been wrong in concluding that there was no gap in the medical evidence, and that he had accordingly been wrong in his case management decision that no further expert was necessary in order to resolve the issues before him and to achieve equality of the arms. Accordingly, there's no real prospect of succeeding in an argument that the trial did not comply with Article 6, even taking into account Article 2. Ground 3. Mr. Quintavalle rightly submitted that the Convention has an interpretive role in relation to Article 2. However, he also argued withdrawal of life-sustaining treatment amounts to discrimination. He does this, however, without authority or further exploration of how Indy has been discriminated against or what type of discrimination she has suffered. Accordingly, permission to appeal is also refused in relation to all grounds. It follows, therefore, Mr. Quintavalle, that permission to appeal the making of the declarations by PLJ is refused.
My lady, we would ask for a short stay in order to make an application to Strasbourg. It's the court's rightly made stays in these cases when an application's been made, and this is necessary in order to comply with Article 13 and ensure that there's an effective remedy for any violations that there may be by the state against an individual. I appreciate that in all these cases, the concern of the court is, especially after best interest, determinations being made to ensure that the person involved isn't exposed to any unnecessary and further detriment and suffering. But nonetheless, without wishing to make any comparisons, which the court has found to be unhelpful, it would be appropriate, as in other cases where these applications are made for a short stay, to be granted in order to be able.
Quintavalle, if you were going to make the comparisons, you'd be telling me also what Strasbourg has said on each and every occasion such a stay has been granted an application may.
My lady, what Strasbourg has usefully done in every case is to respond very quickly and usually within 24 hours. In fact, recently always within 24 hours.
I'm aware of that. There's a...
But my lady, every case is different, and because other applications haven't been successful, doesn't mean that Indy hasn't, through her father, a right to make this application in this case too. We're not asking for more than a few days.
Indy's not making the application because Indy has a children's guardian who is not making such an application, as I understand it. It's the father's application, which I take your point exactly, that he's entitled to make if he wishes to.
So, my lady, would be asking just for a short stay, but
what do you call a short stay before I ask the trust and the guardian for their observations on this?
We'd ask for 2 or 3 days, 2 days to enable the application to be made and another day to get a response from Strasbourg. This would be a different application to those that have been made in other cases. And I think whilst I accept that the court has shown deference to the decision making of the UK courts, this does raise different issues relating to procedural, we say, concerns, and I've cited a whole load of cases on point. So we'll be asking for 2 or 3 days.
Thank you very much, Mr. Quintabani. Yes, what does the Trust say about it?
Well, my lady, as you know, the stay was until the conclusion of the hearing today, and the hearing was before His Lordship 2 weeks ago, and the concern of Dr. E, who sits behind me, is that the up-to-date witness statement, which my lady and my lord have before you, show the gravity now of Indy's situation, and it's hugely disappointing, but perhaps not unforeseen in the way in which the legal team on behalf of Mr. Gregory conducted this. So I have taken instructions on this. From a very recent case, although I accept the point about similarities, 48 hours was given in light of the time today. My instructions are that if the court agrees that there would be a stay to implement the terms of the order until 10 o'clock on Thursday, the 26th of October, that 48 hours, all of Tuesday, all of Wednesday, is a realistic time frame in light of a very recent case which my learned friend is aware of if they're seeking to utilise Rule 39 as an interim measure. So 10 o'clock on Thursday the 26th of October we would be amenable to, albeit with a heavy heart, because, as I stated, the medical evidence is overwhelming now, and the summary that my lady has makes things extremely clear as to Indy's state.
Thank you, Guardian. My lady, I don't think I can add very much other than to say the shortest time possible given the evidence that the court has before it. Mr. Quintabani, you think 10 o'clock on Thursday is a bit tight for all of you to do what you need to do and for Strasbourg to consider it. So we'll give you your stay until 4 o'clock on Thursday. That gives you the rest of that day.
Very grateful.
Mr. Quintabani, may I say through you to the father, who I can only observe as PLJ did, has conducted himself through what must have been a very difficult and long day with great composure and dignity. The court offers our profound sympathies and understanding as a parent to both him and his partner in relation to Andy's illness.
I shall relate this.
Thank you. Now, is there anything else that I can usefully do to assist?
Just one matter in relation to the reporting restriction, because
Yes.
that was worded in terms that saw a final hearing having been determined before now. There was consideration, my lady, in relation to there not being an indefinite order. That's clear that
Yes.
those orders are long gone in relation to how these matters should persist. There was discussion in relation to the order being framed that it would be lasting until 8 weeks after Indy has died.
Yes.
That struck the right balance in
Yes.
relation to matters being settled. There's various analysis by Lord Burnett in Abbasi in relation to the risk of harassment associated
Well, I
with...
sat with Lord Burnett, and so I remember very clearly
I'm very
the
grateful.
terms of the...
Yes, it's paragraph 38 and
Yeah.
paragraph 121. The best point I can make, and I don't know if this is going to be opposed, but the court is astute to protect from harm individuals caught up in the litigation when it's appropriate to do so, and this is the important point, in appropriate circumstances, that protection will include the use of injunctions to mitigate the risk of future harm, and experience has shown that end-of-life proceedings can generate a firestorm on social media. Just to use what's happened today, by reason of the live streaming, there has already been a number of significant negativity targeted towards clinicians. So the onus in relation to having...
What, on social media?
Yes, so it was on Facebook. There was various comment in relation to the proceedings this afternoon, and it just shows that there is up-to-date concern in relation to the risk of online abuse to all of those included in the case. And although my learned friend referred to a clinician in Germany, the impetus on the report and restriction order that's currently operative was it was going to be all treating clinicians and those involved in the case. So all those who have the potential to be abused online in light of the decision that's been made by the court. So it's twofold. It's the risk of online abuse, but it's also the risk that clinicians will not be able to implement the very intensive care that India requires. So for those two reasons, and recognising that there needs to be a proportionate analysis,
Yes.
the 8 weeks is sought. So if the report and restriction order could be amended in those terms,
So
I can
8 weeks after withdrawal of well, not after withdrawal treatment, after death.
Yes, and I appreciate that's very sensitive, but I can draw that up for my lady's approval.
Mr. Kuntavalli, I realise it's very, very difficult for your lay client to think about this issue at the moment, but I will come to the Guardian in a moment. Have you any instructions about such an amendment to the reporting restrictions order?
So the instructions I've got are that he's opposed to this. If he would be amenable to a shorter period of time, or the reason for that opposition, I don't know. But what I can say is it may be useful if I could just have a minute just to discuss this, because it's not a matter which...
No, well, I understand that fully. Let me just hear what the Guardian has to say, Mr. Kuntavalli.
Yes.
Just sit down for a moment. Yes.
I don't seek the Guardian's name to be withheld going forward.
Thank you very much indeed. Right, Mr. Kuntavalli said the position is the Guardian doesn't seek any continuing anonymity. So the proposal is in accordance with the most recent judgment from Burnett that a proportionate short period of time after the conclusion of proceedings and after treatment has been withdrawn is helpful and the sensible way forward. I think actually in that judgment we mentioned 3 months, or 3 months was mentioned, but the trust are actually not seeking as long as 3 months. They're seeking 8 weeks.
Those cases were long. Several years had passed since the cases.
Oh yeah.
But the case where a limit had been set was the Rien case, which was 28 days from the time when treatment
Well,
was withdrawn.
Mr. Kuntavalli, I'm not going to
Yeah,
get into comparisons again.
No.
If you would like a couple of moments, I'm sure everyone now is so late now. I suppose I'm sure everyone would say, well, for another few moments, let's try and resolve this matter. And if you'd like a couple of moments in private with your lay client, that's fine. Or would you like us to rise, or do you want to slip out of court with your client? What would you like to do?
Maybe it'd be easy if we just slipped out very quickly.
So, no, of course, you must do that.
I'm very grateful for that
Not at all, Mr. Quinfarley.
short opportunity to explain matters and to take proper instructions. My client is content to go along with the 8 weeks proposed by the trust in the circumstances. He does believe that it's important that there can be discussion, particularly in the context where he's concerned about the sort of evidence that was there, but understands that concerns that have been raised. And he hastens to add that he has nothing to do with any online harassment which we're told has now been occurring. And that's certainly not something he wants to associate with. The only concern, and the court may feel this is a rather remote possibility, but this order has the potential to be open-ended, and that is a concern that I would want to raise, because the 8-week period starts from Indy's death, and that is very likely to happen if treatment is withdrawn, but it may not necessarily happen. And I would certainly be concerned if this, in that remote, the court may feel remote circumstance, that this turned into an open-ended injunction.
Well, I mean, I can see that as theoretical possibility, but in the light of the evidence and the judgment which you've refused permission to appeal against, I think that is a most unlikely outcome. However, of course, if that event does come about, then you will be perfectly entitled to make an application for variation of the order.
I'm grateful.
Thank you for raising that matter. Anything else? I apologise. So, can we have a fresh draft of the reporting restrictions order, please?
Absolutely. Will tomorrow morning be acceptable,
Yes.
maybe?
Yes. Mr. Palmer, you and the press can
With your
happily...
permission, just make a practical point. If the order will run, relating to the clinicians, will run from 8 weeks from Indy's death,
Yes.
is it okay, as we've done before, just to make an arrangement, perhaps with the trust solicitor, just so we can be told when Indy dies, so we know that how long the order is?
Yes.
That's okay. Thank you.
Thank you very much, Mr. Palmer.
Yes, certainly that will be done.
Yes, I think that's become the way that it
Yes.
tends to be dealt with now.
It's just, I mean, I hope
You
it goes
can't
on
count-
for a long time before she dies. It's just a practical thing,
No.
so we know what orders we're dealing with.
No, well, you can't count if you don't know the relevant date, can you?
Yeah. Okay. Thank you for letting me address you. Thank you.
Anything else? No? Well, can I thank you all again for sitting so late? I think it was extremely important for all concerned, but particularly for Indy's family and also for those who are treating her and dealing with her on a 24-hour basis, that decisions are made. So the will be the stay, as you will incorporate into the order.
Of course.
48 hours. Mr. Quinfarley, can I just remind you so that you can explain again to your lay client about it? My rather rough draft will, in the normal way, be a copy of that will be sent to Strasbourg in the morning. It'll just have to have my quotes inserted into it, but otherwise it will be roughly as I've spoken. Obviously, when you speak something out loud to a rough draft, it's a bit different, but it has all the essentials and will be sent in the way that we always do our judgments to Strasbourg.
Very grateful.
So that by the time you've made your application, they will have a copy of that. I presume that everyone's happy with that.
Absolutely.
Excellent. Thank you all very much indeed.